Hello, my name is Chris Rootham, and as you've heard from the first of the two Collective Bargaining 101 presentations, I'm a lawyer with Nelligan Law in Ottawa, working closely with the National Police Federation. This video will be shorter than the previous two, and it deals with the topic of interest arbitration. You'll remember from the first video, I outlined the three stages of collective bargaining, that there's the negotiation stage, and if you don't reach an agreement at negotiation, there's mediation, and then there is mediation arbitration, which is another way to describe interest arbitration. The first two videos I did are about the negotiation stage. Similar to the videos that Bill Cole is presenting are going to be about the negotiation stage. This video is just about the final two stages, mediation and mediation arbitration or interest arbitration. Mediation is a brokered settlement discussion. And so there's a third party who either the employer and the union pick themselves, or typically they're appointed by the labor board. And this third party comes in and they try to help the parties reach a deal. They try to assist the parties in reaching a voluntary agreement. This is a voluntary process. You don't have to participate in mediation. And if you do participate in mediation, you don't have to agree with the mediator. You don't have to agree on anything at mediation. The mediator is there just to help you try to bridge the gap between the two parties. They're not there to force a deal on you. Mediation, though, can be helpful. Sometimes having this broker, this third party there in the room really helps the parties come together. Sometimes they get all the way together. Sometimes they get part of the way together, and there's a value in that. There's a value in narrowing the issues that are in dispute. If you have 40 issues in dispute and you show up at mediation and then you go through the mediation process and you've resolved half of them, well, that's a successful mediation. You're a lot further ahead than you were before. So that's mediation in a nutshell. If you're not successful at mediation, then you move to interest arbitration. Interest arbitration takes place in front of an arbitrator who is a neutral third party, typically selected by the parties. If the parties can't agree, the labor board selects one for us. The arbitrator is neutral and is there to decide the content of our collective agreement. So you have to persuade the interest arbitrator about the content of your collective agreement, and the interest arbitrator's decision is final. That will be the collective agreement going forward. Interest arbitration usually takes place in front of a panel of three people. There is somebody that we nominate, and there's somebody the employer nominates. We call those the side members or the nominees. Our nominees are people that we select because they understand our issues and are able to communicate them properly to the chair of the neutral chair of the interest arbitration panel if necessary. Then the nominees select the neutral chair with our input. And if they're not able to select a neutral chair, then the labor board selects one for us. Then there's a hearing. The hearing takes place, it's a little bit like a court process, but also the interest arbitrator, unlike a neutral judge, can meet privately with the parties, can discuss with the parties, what is this proposal really about? Help me understand this as I try to also assist you in coming closer together. So an interest arbitrator, or at the very least a very good interest arbitrator, also tries to act like a mediator, also tries to get us closer together to an agreement. And so they only have to make a little decision, not a decision on a huge number of outstanding issues. There's some back and forth that goes privately and also publicly with the arbitrator, with the interest arbitrator about that. There are 6 founding principles for interest arbitration. The first is replication. An interest arbitrator is not there to decide who's right and who's wrong. The interest arbitrator is going to decide, what do other people do in similar circumstances? I am here to replicate what would have happened if you had reached a voluntary agreement. I'm not here to tell you who's right and who's wrong. I'm here to tell you this is what your agreement should have looked like if you have reached a voluntary agreement. And the easiest way to do that is to copy what other people have already agreed to. In other words, we're more likely to reach an agreement that's similar to other agreements. So an interest arbitrator will look at what do others earn? What are working conditions like in similar workplaces? It's about replication, not necessarily about who's right and who's wrong. The second thing is that interest arbitration is inherently conservative. There are no big breakthroughs. They're there to resolve a dispute and make necessary adjustments, but they're not there to make a huge change. They're not there to change the world. If you want a huge change, you have to buy it in collective bargaining, or at least that's what interest arbitrators think. What flows from that is if you want to make a change, you have to demonstrate the need for the change. Tell me why there's the necessity for the change. Back it up with data, back it up with stories, back it up with a narrative, back it up with the actual working experience of members. You have to demonstrate the change, not just explain it in the abstract about why this change would be useful. Fourth, interest arbitrators take a look at the big picture. They take a look at the value of the total compensation. How much does this change cost? What is it going to do to change your total compensation? And also comparison between the agreements that you're trying to replicate. So there are a lot of collective agreements out there that have a lot of terms and conditions that are better than what the RCMP is. An interest arbitrator is not going to say, copy all of those. The interest arbitrator instead is going to say, I'm going to copy some of those, but only when I look at them in the aggregate, am I out of whack in terms of your total compensation. This means that the interest arbitrator is going to measure the impact of the outcomes. How measurable is the difference in settlement outcomes? And finally, comparability. This goes back to the first principle of replication. Who am I replicating? Who are the suitable groups for me to look at? Who am I comparing you to? It's our position we should be compared to other large police services. Treasury Board might have a different view. They might want to compare us to the rest of the federal public service. And an interest arbitrator is going to have to decide who is the appropriate comparator. Large police services, small police services, broader public sector, federal public service, who's the appropriate comparator? Usually police services are compared to other police services, but this is going to be an issue if and when we do have to go to interest arbitration. In addition to those criteria, there are some statutory criteria. I have them up on the slide. I don't propose to read them to you, but broadly speaking, they involve recruitment and retention. What wages do you need in order to recruit good people and retain them in the workplace? What sort of terms and conditions do you need to recruit and retain good workers? What is your external comparability? How do you compare to other employers? What is your internal comparability? How do you compare to the rest of the public service? And is your wage rate growing over time greater than the rest of the public service? And if so, there might have to be some adjustment for that. Or are you falling behind the rest of the federal public service? And does there some adjustment have to be there? Responsibility, you need to establish compensation that is reasonable in relation to the qualifications and the work, the level of responsibility that somebody assumes. You get paid according to your qualifications, and you get paid according to your level of responsibility. The more responsible your work is, the more you should get paid. That's a statutory criteria. Interest arbitrators are allowed to look at the broader economics. They're allowed to look at the government of Canada's fiscal circumstances. And finally, they're allowed to look at, or they must look at, the operational effectiveness of the RCMP. What does that mean? To be candid, we don't know for sure yet. We know what the MPF thinks it means. We know what the employer thinks it means. Those are not the same thing. And so it's going to be for an interest arbitrator to decide on a case-by-case basis how operational effectiveness comes into interest arbitration. This is the law of interest arbitration put very quickly. If you're going to take one thing away from this video, it is this. Interest arbitration is not always about who's right and who's wrong. It's not enough to say to an interest arbitration, excuse me, that we are right, we deserve X because it's reasonable, or we deserve X because we can provide you good reasons for it. Arbitrators are also going to look at, well, if it's so reasonable, why couldn't you get it in bargaining? Do other people have it? Who has it? If they have it, did they have to give something else up in exchange? And are you asking for that something in addition to the new proposal? So interest arbitration, it's not enough to be right. You have to also show that other people have got it, and that in the aggregate, what we're asking for is reasonable. So that concludes this video. Thank you very much.